afternoon, everyone. My name is Sue Botello, and I'm one of the professional practice associates at the college. I'm also a registered social worker. Thank you for joining us today for this panel conversation. It's called Serving Older Adults with Competence and Compassion. I'm now very pleased to introduce to you our panelists. We're going to begin here to my right. We have Joy Friesen, registered social worker and the Director of Community Programs at Hospice Niagara. She is a passionate advocate for consent, autonomy, and respectful care, and for elevating the voices and rights of equity-deserving populations. Sandita Singh is a registered social worker and the social work professional practice lead with the City of Toronto Senior Services and Long-Term Care Division. She co-leads a divisional ethics program and supports the Center for Learning, Research, and Innovation in Long-Term Care Community of Practice for Social Workers and Social Service Workers. We also have Alistair Smith, who's a patient advocate with a public policy background. He brings lived experience as a caregiver and advocate for his spouse and his aging, medically fragile parents, as well as his experience of navigating the world and health systems as a trans man with multiple chronic health conditions. And then we have Laura. Laura Tamblin-Watts is the CEO of CanAge, Canada's National Seniors Advocacy Organization. She is a lawyer, seniors advocate, media commentator, and author. She is also an assistant professor at the Factor Inwentash Faculty of Social Work at the University of Toronto. You can read the full biographies of all the panelists on the virtual portal under the Speakers tab. Please join me in welcoming our panelists. Thank you. I will now go briefly through a few things. I'll set the scene as we move into our questions. Working with older adults is a rewarding experience, especially when you can provide comfort and care during difficult times in a client's life, which can include end of life. Frequently, older adults are assisted by their adult children and family members, and while this can create complexity, it can also allow for generational healing and support. Registrants providing care to older adult clients are oftentimes also providing support to the client's family, who are navigating and coping with the client's changing circumstances. While there is no specific consent legislation for the older adult population, there are contextual differences that registrants must be mindful of. As required by the College's Standards of Practice, registrants must keep a client's best interest as their primary professional obligation and obtain their client's consent for treatment. This can include having a do not resuscitate order, medication changes, medical assistance in dying or MAID, palliative care, or placement at a long-term care home, among other things. It's the responsibility of the professional offering the treatment to assess for capacity, and in some organizations, there is a team approach to capacity assessment. These situations can be further complicated when a client has fluctuating capacity and or a number of power of attorneys who don't always agree with the treatment proposed. A few notes on the terms that we'll be using during the session. We'll be referring to power of attorneys for personal care as POAPCS. We'll be using the terms client and patient interchangeably. When we say caregivers, this includes everyone from an older adult's family members to hired carers to friends. And as we are going to be discussing consent and capacity during this session, it's also important to understand what we mean by these terms. Consent means a client's voluntary, informed agreement to receive a specific service, intervention, or treatment. Capacity, in this case, is referring to mental or cognitive capacity and means the client is able to understand the information relevant to a specific decision and understand the reasonable consequences of making or not making that decision. So we've got that out of the way. It was very important, I think, to give some context and knowledge in terms of what we are discussing today. And thank you again for joining us at the college. We're just going to start right away, but we want to center our conversation around the client first. So at times, and I'm going to be asking, I'll let you know when I'm asking your question for the purpose of our time today. So we're starting with asking about the fact that there's multiple voices that have differing opinions on proposed treatment plans. What are the strategies for registrants to keep the client voice central to all treatment planning? So I want to start with Sandita and then go to Alistair, Joy, and then Laura. So start with Sandita.
Thank you, Sue.
Mhm.
So great to be here with everyone today. So keeping our client's voice central is a shared responsibility across interprofessional teams. As Sue talked with us this morning about, the fact that we are registered, regulated health professionals or practitioners. So we do have professional, legal, and ethical obligations to support autonomy, to support informed decision-making, and to support resident or client-centered care. So yeah, sometimes, teams will have different opinions about things like risk or treatment options, or what they believe is in the best interest of the person. They believe the right thing to do is X. So I think these differences of opinions can be quite valuable, because when we're able to respectfully work through them and talk through them, they can challenge our assumptions. They can help us recognize biases, and they can really ensure that we're keeping what matters most to the person at the center of planning and not what we think is best. And I'll just take this one step further because I think settings matter. So although we're talking about like focusing on one client, sometimes we have settings where there are multiple clients that could be impacted, like a congregate living setting, for example. So it's really important as registrants, and we're advocating so strongly for the voice of our one client and resident, that we are able to hear the different opinions around, well, what about the best interests or the interests of the other residents? So that's really important. I think really it's about continuing to ask, like, have we spoken with the person directly? Do we know what matters most to them? And are we continuing to support, their interests and their preferences?
Makes good sense. Thank you. Can you hear from Alistair?
This is going to be more anecdotal than anything, I suppose.
Absolutely great.
Just for a little bit of
Important.
context, we lost my dad last year after quite an extended period in which he was struggling with Lewy body dementia, which of course has fluctuating capacity. One of the things that honestly is just a bit of a tip that I found very helpful when taking him to appointments was to have like a half-page summary available for the healthcare provider. Because what that allowed it to happen then is that they asked fewer questions of him, because the more questions that they asked him, he would fatigue easily and he would tend to get more confused the more questions he asked. So by providing the sort of necessary background up front and in a really easy format, the healthcare provider was then able to sort of pinpoint the questions that were important for him to answer, without having to be more confused or more fatigued by the interaction than necessary, if that makes sense.
That's very helpful. Thank you for putting that client in the central part of that conversation for that treatment planning to happen.
Yes, really just focus in on the part that was really necessary for
For
him.
him. Okay, awesome. Thank you. Okay, I'll hear from Joy.
Well, I just want to take a step further in terms of your, Sadida, you mentioned that, at the end of the day, it's the client, is the older adult, so it's the center of the treatment planning. And I want to put a step further in terms of, okay, so we want to speak to the clients themselves, to the older adults themselves. However, we have to be mindful of probably barriers to communication, right? So if the older adult is a newcomer or English is not the first language, do we have interpreters available? Even sometimes be mindful of, are we aware that the older adults probably taking medications in the morning? Are they sleepy in the morning? So probably making sure that we are trying to factor those possible barriers of effective communication with these older adults. And one thing that I would say, a most important thing that I would always share to registrants is document, document, document. Because once you document earlier conversation, when similar possible challenges or issues might arise in the future, you can revert back to that documentation to, guide the conversations. And one thing too is that we have to be mindful of silence. Sometimes we might assume that silence is, oh, they're agreeing with me because they're silent. No, because probably that person is silent because of, experiences from the past. If we are aware or be mindful of that person's or older adults' background, maybe if they're coming, like I'm speaking on behalf of my experience coming from a minorities, that in our experience sometimes we are conditioned not to challenge the doctors, not to challenge the physicians, even though we're not agreeing at it. So be mindful of that silence is not always mean, yes, I agree with you.
Thank you so much. And Laura, to hear from you.
I'm going to put my lawyer hat on. I'm a lawyer who teaches in the Faculty of Social Work because I usually think if you have enough money to afford a lawyer, I'm not that worried about you. I really want to make sure that the 99% of everybody else has what they need. And really, I think most issues are actually people issues. They tend not to be as much legal issues. But I'm going to say three things. The first is, wearing my lawyer hat, it's important to understand that there is a nuance, and it's not really a small one, but there's a nuance between what's called the best interests, which as professionals, you often have to work towards the best interest of your client. But the substitute decision maker, if that person is mentally incapable, substitute decision maker, that power of attorney for personal care in Ontario, does not actually have to move to a best interest standards. Their standard is to work for personal preference. What would this person want to do? I call it the Vegas test, although right now no one's going to Vegas as Canadians, I understand that. But let's call it the Niagara Falls casino test, right? It's not a smart thing to do to go and spend your money in a casino. It's not clever, it's not smart, it's not wise. Many people do not make good life choices when you're there, but people go there because they think it's fun and they want to do it, and they'll spend their money in this unwise fashion. That's the personal preference. The best interest is that all your money would go into a GIC with a very, very low risk, and you'd lock it down and you'd keep everything safe. And frankly, most people live somewhere in the middle. And that's the reality. That's the human reality layered onto these legal tests. So if you are, as a professional, are saying the best interests is to do X, probably live in a very conservative environment, make sure that you eat right and exercise, make sure that you take every medication, that is maybe in the best interest, but it may not be what the person wants. And if that person is mentally incapable, if they've got significant dementia or they're in a coma, the substitute decision maker is in this difficult position because yes, we should do all of these things, but that's not what mom would want. Mom would want maybe a shorter life, but more active life. Or mom might want to be at home, not in long-term care, even though it would extend her life to be in long-term care. It is important to understand that we bump into that in terms of professionals, where you are trying to make sure that you're giving the most medical, social, health framing, and then understand that it is in the end this personal choice. That can create some tension, and we have to be okay with that tension. The second thing I'd say is ask, why am I assessing this mental capacity issue to begin with? Mental capacity is not a legal thing. It's not a medical thing. It's a made-up thing. It's a social construct. Lots of people were mentally incapable. Women were mentally incapable. And Indigenous peoples were considered mentally incapable. Children are considered mentally incapable. It's a made-up idea that lawyers put on something. And as we change our thinking, those old and outdated approaches change too. So ask yourself, why am I doing this test, and is there anything else I can do to avoid doing it? Because you are infringing on that person's human rights, their civil rights. If they're found to be mentally incapable of doing something, they can't have sex, they can't make their own health decisions, they can't figure out where they're going to live, they can't clothe themselves. These are fundamental issues. So ask yourself, is there another way that we can get to where we need to go to through the skills of social work and social service work, rather than giving a mental capacity assessment, which is a very fundamentally rights impacting issue. And I guess the last thing I'd say is, What are you assessing and why? That's a different question. Is it you're supposed to only assess the smallest slice? Can they make this surgical decision? Can they make this decision to go into long-term care? Very often people do sweeping assessments because of course you're there and you got them doing it and let's just figure out everything. No, actually our requirements are to answer the question up front, capacity for what? And then only assess that.
Okay. I appreciate all of that. That's really helpful. I know we're going to get into some of these questions further along the way as well, particularly around capacity. And we are always considering what the client's best interest. We talk about our standards of practice as well. So that's all the way through. Thank you. Appreciate in terms of identifying where the client voice might be, whether it be a representative for the client, an SDM or power of attorney, or whether it be them themselves. So I appreciate some of the input we've had. Part of the question too would be just to ask, in terms of when you see a practitioner bypassing a client, making the decision on their behalf and rather than, sort of get their input. Do you have any for our registrants who are checking in today? Is there any consideration that, you have for how to navigate working with practitioners who are bypassing clients? So I'll start with you, Sandita.
So firstly, I think it's really important not to assume bad intentions, right? Bad intent. I think that teams are often navigating complexity, time pressures, and uncertainty. So in these situations, what I find helpful is perhaps offering to meet with my colleague and the client to have these conversations, or my team and the client to have these conversations, because it's really a way for me to help not only demonstrate the importance of centering these discussions on our clients' values, goals, wishes, preferences, but I am modeling to my team how they can have this conversation in a really good way. And I find that what that does, it does help to build confidence, it strengthens practice, and it really continues to center on the resident's voice. It's a difficult thing, and we have to continually ask, are we engaging with the resident? Are we creating opportunities for them to participate? Are we valuing their voices? So I think that's definitely
really helpful. Yeah, because as a team, right? Like it's easy to kind of fall back, and especially in the multidisciplinary that we were discussing earlier today. So thank you. I think that's very clear to continue to push that, not to give up on that. So yeah, it's appreciative. Now, did you have some insight as well?
For sure. I think it's more about sometimes social workers, we are very timid in terms to pause a conversation. If we see the doctors and physicians having this meeting and sometimes we feel timid to wait a minute, let's pause this conversation. Do we know actually what the person's wishes? Do we know if there's capacity? Do we know if it had been assessed already? Things like that. And we have to be minded or guided that, capacity is time specific, decision is specific. So at a certain decision or a certain topic, they are able to make the decision at the time probably. So we have, it's not like if they were deemed incapable, that they're incapable all the time and incapable of all the topics. It would be time specific, decision specific. And I would say that if after we hold on and ask to pause the conversation and they continue to not listen to the social workers intervene, we have a professional obligation to escalate this. So maybe we needed to contact, if the agency has a consent or capacity lead, maybe escalate it to your supervisor, to your director, things like that. Or maybe I have called, I myself, as even a director at Hospice Niagara, there are several instances where we contact the college and ask for guidance, right? And sometimes it's not that we don't know the answer. We just needed someone to process those thoughts sometimes, right? We have to be very critical though, because older adults' voices sometimes are being silenced because of ageism, ableism, and sometimes the assumptions that, the older children knows better. The daughter knows better. She's a social worker herself, so we should listen to the daughter. So I think we should be mindful of that.
Must be hard to experience and then see that as well.
Yeah.
Frustrating. Legit. Alistair, if you have any follow-up to that?
I don't have any follow-up for that, though.
Okay. Laura, do you have any
I
follow-up?
just say sometimes to slow down, have some grace. People are trying to do what they can, often in difficult situations. But often we don't actually teach people how to get consent. And it sounds ridiculous, but the last time I looked at the doctor's curriculum, there was something like 24 minutes on everything to do with mental capacity and consent over the course of 4 years. So about 6 minutes a year. And I think I teach the only class that's on law and aging and law and consent, I think in a social work department in Canada. Like, we don't teach people. The nurses actually pay a lot of attention to this, but it depends. And it may be 30 years ago that they did their schooling as well. And so trying to figure out how to get consent, what does it mean? What is it meaningfully? How do you do it? Both the art and the law of it, I think we need to just double check to make sure that people have that skill. And it might be kind of the thing where you actually do some role playing, you bring some continuing education in and support people in making sure that they have the tools that they need to get the decisions that they're supposed to be getting.
I think that's a great way to describe that. And then like the supervision, the training, the education, the role playing, making it a safe space for people to be like, well, I need to interrupt you about that. Or, what does that sound like when you speak it? Sometimes that the dynamics are so impacted when you're at least in a place where you can practice and talk about, no, we're not gonna, just make a decision for this particular client. We're going to listen and we have to stop and think about that. So it's really, really helpful. Laura, I know you've talked about the role of the power of attorney a little bit. If you could just briefly touch on the difference between power of attorney and substitute decision maker. And again, we're talking about power of attorney for personal care.
So in Ontario, everybody who is a power of attorney for personal care is a substitute decision maker, but not the other way around. Only about a third of Canadians actually have personal planning documents. Only about a third. So in this jurisdiction, we call it power of attorney for personal care, power of attorney or continuing power of attorney for property, and then after they pass away, a will. But only about a third do. So that's assuming a third of your clients have it. It also means only about a third of their care supporters, if they're lucky enough to have care supporters, have them or even know about them. So the majority of people that you will be supporting do not have power of attorney for personal cares in place, right? About 2/3 will. So that means you go to what's called the Healthcare Consent Act. And it's more awkward, it's for sure, because it doesn't have an established set of choices. That person hasn't chosen that one. There's a default list under the Healthcare Consent Act. Not everyone has somebody in the default list. It's very old legislation. And it really is not family of choice. It doesn't have close friends in it like BC does. It doesn't have a broader understanding of decision making. It's really that old idea of kind of blood next of kin. And if you may end up calling up the 95-year-old parents of a 70-year-old, which I did because that was actually the person who was next on the list. I remember him saying, "Are you kidding me? Like, I guess you never stop being a parent because like I'm 95 to my 70-year-old." And so it's awkward. If there is nobody on that default list, right, which goes, it's kind of who you think is a spouse or partner, and then goes to sort of, kids and parents and siblings and so on. And then it goes to any other relative, by birth or adoption. That could be your third cousin who lives in, Red Deer, Alberta. As long as you're not at odds with that person, there's some elimination. They can't themselves be mentally incapable, which makes good sense for any substitute decision maker. You have to be a person that can do it. You have to be of a certain age. In Ontario, it's 16, so it's very young. It's very young to be a substitute decision maker. You can make a power of attorney for personal care at 16 too, so get your kids and your grandkids to get doing it. But it's awkward because we often talk about substitute decision making like, oh, of course there's a power of attorney for personal care. And people will show up and say that they are that person, and they may really believe that they are, but they're not. The other important thing is you have to see the document. And in a very digital world, that's often awkward too. And the worst place is they leave it. They'll often leave it in a bank, and then you can't get it because you need to have power of attorney for property to unlock the vault to get in to give the power of attorney for the bank. So it's very awkward. So mostly you're probably going to be dealing with the Healthcare Consent Act, and you've got to try to figure this out. And it's not easy, it's not ideal. And it also means that every category of people are equally ranked. So let's just say that you're an older adult and you're blessed with 5 children and none of them agree on the time of day, let alone your care. We're locked.
Yeah.
Try to manage it. If the end there's nobody or nobody can do it, it goes to our public guardian and trustee.
Okay.
And they're very busy and they don't want your business.
Thank you for that very thorough explanation. I appreciate all that. And the last one there, yep, you're right. You want to make sure you get everything in line. And that's going to just bring me about the equal ranking, as you mentioned, just leads us to our next conversation here with Sandita and Joy about what happens when there is equal ranking. And to keep in mind, I mean, some of our registrants, when they reach out to professional practice, they will ask for some very specific support. We don't give best practices at the college. So, these are the kinds of questions they ask us quite a bit. And one of the reasons why we're doing this panel. So thinking really concrete in terms of what happens when you have 2 people of equal ranking. I'll start with Sandita and then, and they don't agree with the treatment plan. Like, what happens?
So I think it's important to recognize that when you have disagreement between equal ranking decision makers, that can be very challenging for everybody involved, including the team. And so it's really important that we start with our role. Our role is not to decide who's right. Right? Our role is to ensure that there is a respectful decision-making process that's consistent with legal requirements and centered on the person's, values, preferences, goals, and wishes. We know that oftentimes the disagreement isn't about the treatment. Right? Disagreement is often rooted in, different understandings about what's being proposed, family dynamics, grief, guilt, fear. Maybe information was shared at different times or in different ways. So it's really, really important to be able to understand what's driving the disagreement and not just rush to resolve it. And what I find really helpful is bringing people back to a common goal, right? People, family, decision makers, they care deeply about the person and they want the best possible outcomes. So I think that's a really great starting point. And if we're able to create a space where everyone's hearing the same information, everyone's able to ask questions, to share concerns, I think that goes a long way to building a common understanding of the situation, and it moves along the conversation. And it doesn't mean that necessarily we're going to move to consensus, but maybe if we've done our facilitation really well, we can have trust and we can have understanding, and then we can move productively towards, getting to a resolution. I think the other really important part, though, for teams to understand and appreciate is that there are formal processes available, and that teams don't have to feel stuck in this cycle of disagreement. There might be a point where you've tried everything. You've facilitated discussions, you've offered mediation, you've shared relevant information, you've done all that you can do. And at some point you may need to consult with the public guardian and trustee to see what the next steps are. And in these kinds of situations, what I find really helpful is sharing information about that process upfront, right? And when you share information upfront, you're not doing this as a threat, but you're doing this to help people understand their roles and responsibilities. And when people realize that, wait a minute, this external person could be making decisions about people we really love, of someone we really love, that motivates them to keep engaging and moving forward to that shared decision.
Great, thank you. Jay, would you have some insight as well?
For sure.
I'm sure.
Always have insight.
This is different too, right? Yeah.
So the way I see it all the time is that I will share an experience in terms of a practical experience that I had when I was very new in the social work field. I have to remind myself before, because my goal is the family needs to be harmonious and they will have a consensus decision. Well, it's good if the consensus decision is the best interest of the client or it's the client's voice. The goal is not about to have a harmonious family relationship. Well, it's good. It's a good plus factor. However, we have to anchor ourselves, which is I also what I did from the past is I have to anchor myself. My client here is the older adult. What's the best interest here? So now the question around is, okay, so what if they will not all agree? So again, the public guardian and trustee. And if the SDM is not legally doing what they have signed for, I think we could then involve the consent and capacity board in this conversation, right? However, that's very drastic, and also is that a family meeting should be also be good. And this is where social workers, you can use your most powerful ammunition in terms of bringing back these conversations. When you have those family meeting, ground the conversation around what was your father's previous wishes from the past. Do you think this is your father would want? Is this his wishes? Wait a minute, is this your fear making decisions, or is this your father's wishes from the past? I think if we try to get into those conversations that are very uncomfortable because it's very human, the human aspect of it, right? Made is a very, very tricky conversations. If we, for example, if we know that the mom or somebody has want to have made when they're no longer cognitively capable, and the children was like, no, we don't want to do that to mom. It is then our legal obligation and ethical and professional obligation as social workers to advocate for that voice when those older adults can no longer speak their own voices. Now, the question that I want to put to all social workers here right now is that, are we ready to jump into those uncomfortable conversations? And if so, ask yourself, do I have the confidence, competence, and skills to manage this? Because again, it seems as easy as like, oh, just have a family meeting. Yes, for sure. But that is a very, very powerful ammunition, but a much needed skills for every social worker.
Maybe I'll just jump and support that a little bit more as well. I mean, breaking it down to kind of both what's going on here and what's going to happen if you don't, I think is very practical, and the what ifs. So this is one of those great opportunities to take some of the materials from the college or from CLEO, the Continuing Legal Education Ontario, CLEO is a great resource, or the Advocacy Center for the Elderly, or my organization, CanAge, and bring some of these physical documents in. Some people don't learn so well verbally. They need to see something. They need to be able to look at something. Getting a sense of their learning styles is important. So have supporting material is my experience, because there are a lot of words flying around and they're trying to figure it out. They may have conflicts. They may decide, you know what, the siblings aren't going to decide, or I don't have to. I can take myself out. I don't agree, but I'm the fifth sibling and I'm just going to not argue against it. Oh, okay. So the rest of you can do it. I don't have to make that decision. I'm allowed to just step back. I don't like it, but I'm not going to argue against it. So understanding the what ifs on these scenarios and having some supporting material is really important, particularly around things like fluctuating capacity, which is such a complicated issue. And I mean, we all know that only a person who has their own cognitive abilities can make a decision at end of life around medical assistance in dying. But this is confusing because the laws are changing and we have track 1 and track 2. And frankly, it can be really hard to understand. People are trying to figure out what palliative sedation is. Is that the same as a DNR? Is that the same as a do not treat? And because these things can move if there's fluctuating capacity, it's very complicated. And so mom may be saying, oh, I want medical assistance in dying. And you're like, okay, as long as you can. And then you're going down the track that as long as that one agreement, you can do it. Like, these are complicated scenarios. No substitute decision maker can, of course, make a medical assistance in dying one. But if mom regains capacity, she can do it. Or you can, as a substitute decision maker, make a palliative sedation decision it's really complicated. I really love that you said that, Joe, because it's that conversation, those what ifs in a very dynamic and complicated emotional and social and legal situation. So my experience is have some paper, let everyone try to decide, and understand that you can take yourself out. You don't have to be the decision maker. And that can be true sometimes if someone, I had a case, for instance, where someone was against themselves blood transfusions, and mom would have wanted one, but they felt because of their own values and beliefs that they couldn't even be involved in a decision to allow it. And we said, that's okay. You don't have to make that decision. You can step back out of that one and you can come back for the next decision. And everything just settled because we were going to the consent capacity board. We were going to involve, but right. And they just said, oh, I don't have to make that decision. Okay, because it is decision specific. So again, I really love how you talked about that. It's going to be such an important thing, again, particularly when there's fluctuation.
Yeah, and I was just going to say, I would like to hear from you in terms of that fluctuating capacity and you know, in terms of a patient advocate perspective, Alistair.
Right. So one of the things that we experienced, and well, this was discussed with Dad's psychiatrist actually, was when he had some decisions to make about estate planning very early in his dementia journey. One of the things he did was have the conversation, the same conversation several days in a row or several weeks in a row to see if he was having the same answers over time, which allowed him to have a better sense of what his real wishes were.
Okay.
The other thing that I would just say that may be a thing to bear in mind is that sometimes the clients, if they are experiencing dementia, don't remember that their capacity is fluctuating. So then you can have a situation where somebody doesn't understand why they're not being asked. And
Right.
it can be very difficult and upsetting then for everybody. I don't have a good solution for that one, but just a thing to keep in
No, it's something
mind.
to reflect on it for sure. Okay. All right. Thank you. I appreciate that. I know we also talk, we have a resource called On Medical Assistance in Dying. So just as an aside too, as a registrant, you know, there's information you need to know in terms of a role you might play in that. But we always do say that, you know, there's nothing that holds you or bounds you to continue forward providing service, except for the fact you have to share information and education to somebody, but you are not obligated to, you know, be part of an assessment team or anything like that. So you could look at our resource that we have on that in particular. I just, in terms, I know we've covered a lot, so I don't want to have a lot of like, you know, duplication here. You know, we talked about strategies already about ensuring that we have the dignity and the autonomy of the older adult, you know, at the center of care. Is there anything more, and I would just maybe turn to Alistair again, if that's okay, just to say, is there anything further, you know, based on what we talked about, you know, having to ensure that how do you support the caregivers to maintain someone's autonomy, you know, on a regular basis, aside from, like you said, some of these good tests of like checking and making sure that the capacity is there? Anything further that registrants can do to support caregivers?
Sure. So one of the things that I think is not always obvious because the client is still there, but sometimes the caregivers are already experiencing the grief of losing them, even though they're physically still present. So then they're in a situation where they're caring for their spouse or their parent who is losing pieces of themselves every day. And so they're actually starting to go through grief even while the person is still alive, which can also be a very long journey, and depending on what their trajectory is, can come and go. So just as a thing to think about when you're trying to understand why somebody would be reacting the way they may be reacting also is that they're already into a grief process. That actually, I asked my mother if there was something that she would like me to share with the social workers today.
Okay.
And that was what she wanted me to tell people.
Great.
The other thing would just be, we had a lot of conversations with my mother about accepting outside help. I think particularly with boomer parents,
Yeah,
tending to be very private,
rigid, and
right? Don't want anybody in the house. I can manage it. Oh, I can't manage it. You can manage it.
right.
Maybe your sister could manage it.
No strangers.
No strangers. And I think as with a long, slow, grinding decline, I think it's also very easy for caregivers to lose track of how good or bad it is.
Okay.
Because when it's the frog in the boiling water.
Right.
When you're in it, you don't know really how far you are in it.
Sensitized a bit
Yeah.
in terms of all that.
And because it's just continuous, like you don't notice that your kids are getting taller until you turn around and look at them and they're shot up. But in reverse. So that's just another thing to be aware of, is the sort of resistance to that, and that people may not be as fine as they say they are,
Right.
and that there are more resources available that they could maybe consider before they desperately need them and it's an emergency. For example, say before the client's elderly spouse is then themselves incapacitated.
Right. And then what, right? That's really helpful. Thank you. And I think earlier on we talked about things like shame and disappointment and all of that. And I think you had mentioned that, Sandita. And I'm just going to jump into some questions around how people who have, well, we have an intersectionality in terms of our population. So we have people from different gender, race, cultural background, and how that might play in terms of comprehensive support for older adults when you're looking through an intersectional lens. So I'm just wondering about what your considerations are for that, just to consider, the full picture when we're talking about, we may not have had that thought, like say 20 years ago. And, I don't know what's happening in terms of your role or with the City of Toronto and people that, I'd love to hear about that.
Yeah, so older adults is not a homogeneous group, right? Age is one factor, one piece of their identity. Their identity is shaped by experiences around race, culture, ethnicity, disability, so many important factors. So for me, the starting point is really beginning with cultural humility. I think that, looking at, rather than assuming that we know about people's experiences and their values, it's important that we show them that we're open and we're curious and we're, open to learning from them about what's important to them, and not making those assumptions. And it's really learning about the person standing in front of us and all the intersectionalities, the experiences with discrimination, cultural factors, language barriers, previous experience with our healthcare system. And I think to practice cultural humility also means reflecting, being able to self-reflect. Because, we have a ton of experience that we bring to this work, biases, assumptions, right? And it's really important to be aware of them and aware and really reflect on how they influence, decisions and how they influence interactions. People don't need us to know every single thing about their identity, right? They want us to create space. They want us to allow them to let us know who they are, what's important to them. We need to build that trust with them. That's our piece. That onus is on us. And I think if we do that really, really well, then they're going to tell us who they are and they're going to tell us what's really important to them.
Thank you. That's really kind of an enlightening way to look at that, right? Because you do want to wait and sit and discuss and see what unfolds, and they can choose. Like I talk always about that self-determination. What am I choosing to share with that the registrant, and then move forward as you build rapport and trust. Thank you. Joy, do you have some comment on that?
Yeah, for sure. But I just want to revert back to what Alistair had mentioned a while ago. I am very passionate with grief theory. I think my academic part of me is jumping.
Yeah.
When sometimes when a loved one is ill, we find that they have a life-limiting illness, we experience grief, but we are conditioned that grief happens when death happens, right? So how am I feeling this grief if this person's still alive? And the way I frame it is that anticipatory grief, right? I've been speaking to Alzheimer's Society of Niagara, and I always talk about anticipatory grief, and that it's very powerful to know that there is a name of the feeling Because sometimes you feel it's, I don't know what, shall I say I'm grieving? Then they would say condolence, So, but now that you know that it's anticipatory grief, you have a name of the feeling. And so you're not just losing it because it's valid, right? So I just want to talk about that. Now, I think in terms of your question
Yes.
around what is a comprehensive support, I think it's rooted in it should be anti-oppressive, it should be trauma-informed, it should be, anti-ageist. And how would that look like is, let's just say trauma-informed, everyone's experience, like not every immigrant's experience is the same. Not how they define independence is the same. Because if you would ask my father when he was still alive, what does independence for him? Independence is I'm sitting beside him as his only daughter. Now, but we are conditioned that no, you should be like, have autonomy, blah, blah, blah. But you do not understand what the person's culture is. So we have to be very open. Cultural humility is the ability to be brave enough to ask that we don't know. Walk me through with this journey because I don't know. Right? I have Filipino clients before and they assume that I know everything that is applicable. I said, no, wait a minute. I'm not the expert of your lives. I might be Filipino. I might have a little bit of understanding, but I don't know you because I'm not the expert of your life. And when you bring back that conversation that you are the expert, you're giving a very powerful, comprehensive support.
Okay. Thank you. That's very, very helpful. I don't know if Alistair or Lori have any addition to that, just making sure that we can cover a few of our other questions. So
I just want to throw a quick one on there is that older queer and trans adults are often forced back into the closet, particularly when they go into care. And that can be complicating factors, particularly if they then need personal care. So just a thing to be aware of, not to make an assumption that just because somebody is old, they had a husband or, that they may have had a very different life than you're envisioning when you look at them right now. And that there can be pressures also from family around that. And just as Sadita and Joy were saying about making the space to know who your client is, I thought that was very, very powerful.
yes, definitely.
And thank you for sharing that. It's really important. Building on that, I think social workers and social service workers need to be really up to date on technology. And age tech is a really important thing. We have this old idea sometimes in our minds if we're saying, well, I don't want anyone coming into my house. Ask, what's the problem you're trying to solve for? Is it that you're worried they're going to fall? We have pressure sensitive flooring now. What's the problem you're trying to solve? Is it bathing, or is it you can't get a hospital bed in, so you need to have someone come in and physically touch you? Remember that dining room that you haven't used since 2003? How about you take out the china cabinets, put some sliding doors in, and all of a sudden you've got a main floor bedroom. So sometimes when we're thinking about that cultural and intersectional approach, understanding that people's idea of technology and privacy and confidentiality are also different, and to open up those conversations and to, I just say, be up on what non-physical people in your house, don't touch me options can be. And many, I'd say Canadian older adults are actually the single most tech savvy older adults in the world. 85% of seniors in Canada over the age of 85 have an average of 5 internet connected devices and use the internet connected every day. We have a different understanding of privacy and confidentiality. You may have no problem being tracked by Apple, but you don't want your kids to bathe you. Maybe that's okay. So we need to bring that into the conversation.
No, those are excellent points.
Yeah, really great.
Yeah. Thank you. That's a really, really, full of so much helpful information for our registrants. Like you're being really, bang on about what kinds of things they can do. And I really, really appreciate that. Again, in terms of time, and I don't want to kind of miss a few of the things that we want to talk about today, I did want to focus a little bit on understanding what happens when an older person living in a community, when a registrant feels that they may have experienced neglect or abuse or mistreatment. We understand that there is legislation in place for people who are in long-term care homes or in retirement homes, but outside when they're in their own home, in their own community, a lot of our registrants ask us a lot. We get a lot of questions about this. So, I don't know if someone wants to start. I think we can start with Sandita if you want to speak about that, and then we can go from there.
Sure. So I think it's really important when we think that there might be abuse or neglect or mistreatment that we do slow down and not make assumptions, right? These are allegations, and we need to collect, gather information, relevant information. And I think we continue to stay curious because I think there's so many nuances, right? I think that there are complicated family dynamics. I think there's caregiver stress and personal histories that we don't know anything about. And so it's really important, I think, that we hear or we create the opportunities to hear specifically from the older adult to gather their perspective, to have that private space where we can speak with them about their perspective and their concerns. I think it's also important that we identify that they're all different kinds of abuse. There's physical, emotional, psychological, and neglect, financial, and then neglect kind of related abuse. And then you have other factors like cognitive changes, communication barriers. You have sensory impairments and social isolation, which could impact somebody's seeking help, right? And then the really important thing is that registrants need to know that they're not alone. They don't have to navigate these things by themselves. There's lots of community resources, there's home and community care, there's respite services, like there's a whole host of community organizations and resources, even the police, that can really support exploration, can really give advice, make suggestions, or even connect you to the right resources. So you're not alone.
All right. That's a great point to pass on to Benjoy. You have anything to add?
Yeah, it brought me to the memory lane. I have this asserted experience before, like similar to this, right? Living in the community, an older adult, I noticed some bruises on the arm. So what would I do? Right. So first is that, talk to the client when it is safe to do so. If there is immediate danger or risk, I will call 911. If it's not immediate risk, but possible risk, then I remember calling the college and ask for guidance about that. Also is that, what I remember is that I have to ground myself around, it's not me that will make the decision, but it's the client. What would they want? What is the goal? For instance, there is possible, abuse in the family home, and a possible suspect is the child. So what would I do, right? Oh, I should remove the older adult at home. That's what I want to do, because for some reason I immediately saw my grandma. But I have to ground myself. Wait a minute, Joy, that's not your grandma. Put your thinking hat. You are a social worker right now. What would you do? So what I needed to do is I applied a harm reduction approach. And how would that look like? Very practical steps. I make sure that I would basically book an appointment with the client random times. So a child or the son or the other child is aware that someone is involved in the mom's life, that she might be in trouble. He might be in trouble if the social worker randomly arrives at 2 p.m., right? So that's what I did before. And over time, with patience and time, eventually this client that I had before decided to accept help. So again, it's sitting in that uncomfortableness that at the time we need patience, and we have to give them the time that they needed be. But again, use your professional judgment. If this person is about to die, call 911, right? That's basically what I can say.
Right.
And it I absolutely agree. And you've both spoken so well about it. Maybe just the one piece that I would add to it is, again, I'll put the lawyer hat on for a second. We know abuse and neglect is not okay. I'll also say that self-neglect is often considered quite a different thing. So not to conflate those pieces, we really need to do a lot of exploration to understand, is it self-neglect? Is it someone neglecting? What's going on, and unpacking that piece? It's a really important, because it could be cognitive changes. It could be a cultural understanding. Something's going on. They may not have any money to understand what's going on there. So I think it's a really wonderful what you've said. The last piece I guess I would just say is, you can't consent to abuse if you're mentally incapable. So this is the put your legal hat on for 1 second, right? If you're a person and you're mentally capable of understanding and appreciating, and this is not a lighthearted thing when I say it's another version of personal preferences. I'm not saying in any parts that family violence, domestic violence, or abuse of another person is ever okay. But people with mental capacity have the ability and right to live and make choices to stay in dangerous and abusive situations. I wish no one would experience that, but you have that right. You do not have that right if you're mentally incapable. And if you're the substitute decision maker because of a default healthcare consent, or if you're one of those lucky 1/3 of the people who actually has been appointed under the power of attorney documents, you have no choice. You must intervene. You have a legal requirement to do so. So that is the difference. If you're working with a client who is cognitively able to understand and appreciate, and I think it's really important that, there's a point in time question. If there's short-term memory and if there's neurological differences, we need to support and understand that. But if you are the substitute decision maker, the person for whom you're making the decision is being abused or neglected, you have an absolute and complete legal obligation to intervene. The problem is you may be the abuser, and that's for probably another different webinar in education.
Okay. We just have a few minutes left. I just want to hear maybe one word from each of you around a creative way to support an older adult in an affirming and inclusive way. And I know it's hard because it's one word or two words maybe, but something that you could think of that would support an older adult as a registrant or as a patient advocate, to support them in affirming and inclusive ways. If you were to let our registrants know, just one or two words. One, you're on.
Warm referrals.
Warm referrals, love that. Yes.
Center on personhood.
Excellent, thank you.
I'm going to paraphrase Sandita and say curiosity.
Amazing, right? Open up that cultural humility, yes. 1, 2 words.
Know your role.
Okay, love it, love it. Stay in scope and also know what you mean to the family, what you mean to the client. That's lovely. And I think too, it's important to just understand that, yeah, you can build social connections, networks if you can, connect with other registrants, understand what's happening, read resources. In addition, also support clients in the community and looking at, enhancing some social interaction or other ways that they can connect or feel connected to community. And that can certainly support, any of their issues that might come up, that you can connect them. The better that they feel connected, the better they're supported in so many other ways and healthy in other ways. So I'm just going to wrap up a little bit here. I just want to say, as we end our discussion, I want to acknowledge that, again, although working with older adults can be extremely rewarding, it comes with its own set of challenges. And as we've talked, or I've mentioned, we get a lot of people who ask these questions, and hence we've had this time today. And it's important as a practitioner or registrant to consult with your colleagues, your supervisors, get some guidance, look out for your own self-care, make sure that you're not getting burnt out, because that can happen a lot in this field. Thank you to Alistair, Joy, Laura, and Sandita for sharing your insights on this very important topic. I want to stress that. And of course, we have the aging population, right? So we've got lots more people coming up the pipe that we're going to have to be very significantly aware and cognizant of how we're going to navigate in the best way that we can with the best interests of the client. So we do have some time for questions if we have questions. I would remind attendees to enter their questions through the chat feature on the right-hand side of their screen. A reminder that the chat feature is only available for those accessing the session on a computer or laptop and not from a phone or tablet. So I will put it over to Raki, who may have some questions for us at this time.
Hi, thank you very much.
Thanks, Raki.
Hi, thank you very much. So yeah, very engaging chat. Everyone is very interested in this topic, so thank you for providing all of your insights. There were a few questions about the Healthcare Consent Act. So is there any talks from what you know and what you can share among provincial government officials about updating this act to reflect more modern times?
The Laura question.
Yeah. We have been trying to get that, and in fact, the Substitute Decisions Act updated it's about 30 years out of date, really, the two of them are. And if you look at other different jurisdictions who have updated it, they have very different legislation. New Brunswick, for instance, just created its new supported decision-making legislation. BC's had a very adaptive and I think much more forward-thinking and inclusive default list for more than 20 years. So I would love to say yes to that question, but I don't know that it's on anyone's legislative agenda, despite constant pleas from the legal and social service professions to actually do it. So that's a great thing to advocate for. Get your college. This is me just personally speaking on my behalf. This is a great thing to update because we are constrained by this really quite out of date, with respect, not very culturally sensitive, not very inclusive piece of legislation. And we have a long way to go to update it. So I think that's a great rallying cry.
Right.
I don't think it's on the legislative agenda anytime soon.
Right, and it's a good plug too if that's something that you want to see advocacy. The Ontario Association of Social Workers would be a really good connection, or the Ontario Social Service Worker Association, who would then advocate for the profession. So that's kind of.
I'm not saying for the college to do it, but I would say actually in other jurisdictions, the colleges did all get together. So I do want to be really clear about that. In the jurisdictions where we've had legislative change, it's been actually almost all of the regulated colleges who have come together in addition to their professions, in addition to the lawyers, in addition to patient advocates.
Yes,
all
it
came
takes- it
together
takes
and
a
said it's
community.
time to consider updating it.
For sure, it takes a community. Is there any other? Okay, do we have any other questions?
Yes. So a lot of these questions were really, sort of case by case scenario, but they're just generally around the power of attorney or substitute decision maker. If there's more than one child involved in the client's life, for example, who was not super present but choose to have an opinion towards the end of the client's life, how would the context of relationships be taken into account?
There's two ways of answering that. I can give you the legal one if someone wants to do the social
I
one.
think we're going to try to, is there from the social worker register?
So the question is, multiple children are involved, or there are multiple children, but it sounds like there's been some estrangement. And so somebody's coming in now kind of at the end of life, maybe.
Yes. So taking in, like, would context of the relationships of these different children be taken into account when it comes to the client's care?
Right. So,
Yeah, that's
so
a legal question.
yeah, that's
Okay.
a legal question.
Okay.
But kind of in a social environment,
if
part
we're
of what I
doing
guess
it
is
right.
if you're looking at it from a social or community or relationship or well-being or grief
Yeah.
management point of view, I think it's important to say that probably needs to be unpacked and supports need to be given to unpack that. If that person has been estranged and we're talking about the default list, we're not talking about an appointment. Probably they were not appointed, but maybe they were. Sometimes people make their power of attorney documents 20 years ago and the estrangement happened 10 years ago. And then you're thinking, oh my goodness, it's that person. They hate each other. That actually would disqualify them. Someone would have to bother to actually challenge it, but it would disqualify you. If you have been actively at odds, and there are legal tests for what that means. It doesn't mean you missed Hanukkah or Christmas or your kid's birthday party. There's actually legal requirements for how estranged and conflicted you are. If it's on the default list, if you're just like one of the kids and it's the kids that are ranking, if you've been estranged, you're usually excluded. Again, estrangement, there's a legal analysis. It's not just they were miffed last Wednesday, right? There's an actual set of circumstances. A couple of years is usually looked at. But this is one of those areas where it's really important. You have to get those legal resources and know it. It's not just all about conflating that incredibly important social engagement, that incredibly important counseling and healing and grief and anticipatory grief. That is so important, but we can't conflate it. There are rules sometimes, and this is where we have a team-based approach. So not everyone has to try to know everything and do everything together.
Right. Yeah. To lean on each other and get more information and understanding. That makes sense.
Yeah, and I just want to add, like, oftentimes there's significant dynamics right? So it depends on your source of information. So you might hear from the daughter, Joe hasn't been involved for 20 years, but in fact, Joe has been seeing dad, once a week. So I think it's really important, and that's why team-based approach is so very important. I think we can't always assume, again, bad intent. So it's not that the daughter is explicitly, excluding her brother, but there are dynamics there, right? And so I think it's just how we use ourselves, how we build those relationships, how we work with our teams, and how we center our resident. Because, hopefully things aren't, such that the resident isn't able to communicate, right? Like hopefully the resident has been talking to staff, and social workers and social service workers have been talking to the resident about who the important people are in their lives, because that's something we do from the very beginning as we get to know our residents and our clients, right? We talk about those important people in their lives. So that piece is really through our assessment of that person and looking at the best ways to support them. Who are your social supports? Who are your support system?
Excellent.
Yeah.
Thank you. Either of you have any additional comments or anything like that? Okay.
Okay, yeah, there's another question about sort of the legislation or legal obligations around mandatory reporting for elder abuse. So is there things in place like that? Do social workers legally need to intervene when elder abuse is suspected, etc.?
Okay.
You want to talk from the college's point of view or from?
I mean, we could talk about, if you would like to discuss the difference between a retirement, long-term care versus community and the mandatory reporting, if either of you are comfortable with that. But Joy, if you...
I think it has been like touched a little bit on some of those questions a while ago, right? So if, correct me if I'm wrong, my understanding is that if older adults is in a long-term care homes or retirement homes, we social workers have those mandatory. You have to report it, but it's different when they are in the community.
Right.
And again, the way I would just, as what I've shared a while ago, is maybe a harm reduction approach would be the best. And if there is imminent risk, call 911. If you are not sure, but there's risk, maybe consultation, because it wouldn't hurt to acknowledge that we don't know everything. It wouldn't hurt to, 3 heads or 4 heads are better than one, right?
Yeah, and I would add, just in terms of we have some information on our website about this, in terms of the long-term care, the legislation regarding the abuse or suspected abuse or neglect of elderly people in those sort of areas of residence, and that it pertains to anybody who does see that. So it's not necessarily if it's either a family member or it could be another staff person who is the one perpetrating the abuse or neglect. So just to keep that in mind, it's quite broad in terms of how you consider whether it's reportable. And there is in our resources, there's the authority. I forgot the name of the authority. Maybe somebody could let me know. They're with a phone number, and you can call and say, you're reporting it. It's like the child protection piece of the world for the aging population who are in, or the older population who are in long-term care residential homes and accommodations. So we do have a resource that speaks about that authority. And I'm not going to get the name right, but that's where you would go and call, and you could ask and consult as well and say, hey, here's my situation. So just to let you know, yes, yeah.
So in the legislation of the Retirement Homes Act and in the legislation of remember, we've got the new name, the Fixing Long-Term Care Act, there are very specific requirements that you must follow. There's absolutely no flex on it, whatever. Now, whether you think they're the right requirements and whether they're practical, again, that's an entirely separate conversation and an important one maybe to have. So I train the police on this as well. You have to report in long-term care to the director of care. There'll be a designated pathway. Every single regulated long-term care home has a specific and regulated pathway. You must follow that pathway. There's no deviation from that. The director of care must then report it. So you are actually never reporting it unless that for some reason hasn't happened. That's also very important. So if you have reported it and nothing's gone up, you have an obligation to follow up on that, but the long-term care home has a designated reporting status. Okay, if you're in a retirement home, it's a slightly different version of kind of the same thing, and it also gets reported up through the director in that way, and they will report. You don't if you're a staff member. Now, if you're there as, and I'm going to say a social worker in particular in this case, if you have a particular authority because of your profession, okay, and all health service workers who have professional designations have this, you must also ensure that it's reported. You can assure that it's reported through long-term care or assure that it's reported through retirement homes. The concern is when you're in the community and what's your role. And that's a very interesting and complicated issue in some cases. There's a short answer, and I don't love to give those because lawyers don't like to give short answers. The short answer is if you are named in the legislation as a mandatory reporter, you must report anyway. If you're not named as a mandatory reporter, you do not have to report, but you may report. Many people are mandatory reporters who do not know that they are mandatory reporters. I remember giving a talk to dentists and said, you are all mandatory reporters, and they had never heard of this. So it's important. It's then important to remember that if there's an urgent situation, you need to do it. In retirement homes and in long-term care homes, there are exceptions to who has to report. So everyone that works there and everyone who visits there, but not residents. So residents don't have to report on themselves and they don't have to report on each other. And that is an important thing because residents are often the ones who see it first. They may, but they're not obliged. So we have very specific resources. Elder Abuse Prevention Ontario is a fabulous resource, tons of information, very clear documents, Canadian Network for the Prevention of Elder Abuse as well. I've done lots of information. There's lots of stuff out there about it, in particular to find out, are you one of those mandatory reporters? And if so, you do have to make sure that you're up to date and what to do and how to do it.
Amazing. Thank you. It's really good to have those connections or resources. I'm not sure if you'll putting them into the chat and that would be really helpful for our registrants. Thank you so much. Any other additional questions?
I think we have time for one more question. This is for Laura again. So
You get a lawyer in the room.
Yeah.
You want to ask all your questions. I get it. When you get a free lawyer in the room.
That's the
This is what's going on here. I understand what's going on here. Yeah. Make her pay for lunch. Go.
So for a senior who has lost the capacity to make financial decisions independently, how can we assist in this client in establishing a power of attorney for financial matters? Or if a power of attorney can no longer be created due to incapacity, what other options are available to ensure their financial affairs are properly managed?
What I love about this question is this understanding that as much as we want to say money and property are all over here, health and well-being are all over here, but the only difference between health and wealth is one consonant. You can be healthier if you have money. We know this. And if people can't get resources, there can be real challenges around that as well. That means that there is almost always a money component to health issues. I had a health incident recently and I had to buy some medical equipment. And financial power of attorney had to go do it because I myself couldn't go there because I was in the hospital, right? It was a health issue. I couldn't get released from hospital until I had the medical equipment, but I couldn't go buy the medical equipment. And so it is so important that we learn about both of those sets of roles. So I really appreciate that. You're quite right. If you have, quote, lost capacity, which is not, I don't love that term, but if it's been decided that you are no longer mentally able to understand and appreciate enough to make a power of attorney for property, you can't make a power of attorney for property. It sounds obvious, but if you are in an emotional state and you're by the bedside and you know you have to get things organized and family's involved and you know you should get something done, and then you're like, well, how do I get them to sign it? And of course, the hard way of saying it is it's kind of like saying, let's make a will, but you're dead, right? Right? If you've already lost capacity, you can't make the document that chooses who you'd pick if you lost capacity to run your affairs. So it's too late. There is no default substitute decision maker for property. It's a shock to people. So if you get hit by a bus, there's that default list. You haven't made a power of attorney for personal care. You're going to get someone. It may not be who you want. And if there's no one, it's going to be the public guardian and trustee. It's not great, but there's someone. There's no default substitute decision maker for property decisions. If you are not one of the 1/3 of Canadians who have made a power of attorney that continues on into incapacity. In Ontario, we call it a continuing power of attorney. Only in Ontario, we call it that, by the way. It's going to the public guardian trustee. If you are co-owner of something, so let's just say I own a car with my husband. If I lose capacity, my husband can make the decisions about the car. If I die, my husband gets the car. Right? Co-owner is a different thing than having your name on something. You can have financial accounts. They're not as common as they should be, maybe, where you have like a helper on the account with a limited amount of money. So it may not be an actual power of attorney document, but maybe you've got signing authority for $1,000 to some kids have it with their university kids. I do that. They can pull money out, but not that much money out, right? So there's some of that you can do. The real challenge is if you actually don't have it, it's going to the public guardian trustee and they're going to get involved and they're going to try to find someone. It's called a statutory guardian.
I'm going to have to stop you there, although I love getting our registrants free legal information, and that's why it's like a lot of this has been really helpful, I'm sure. But we do have to end, and I thank you so much for all of this, for all of you. It's been really helpful. It helps our registrants understand what it means to be, on the ground, learning, understanding the law, understanding the day-to-day support services, and, just working together as teams and with the clients in the central aspect. So I really, really appreciate all of your insights and your different perspectives. It's been very, very helpful. So I'm going to wrap it up there, and it concludes our session. The next educational session will begin at 3 p.m. You can access the live streams through the Sessions tab. And thank you very much for attending today.